Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer. I want to talk to you today about fraud and what is often called common law fraud. And we'll talk about the elements that you have to meet to prove fraud. And then we'll talk about the difference between a misrepresentation and a suppression. And then finally, we'll talk about something called promissory fraud. So this type of fraud, typically called common law fraud, is a little different than what we might use when we're suing under the FDCPA, the Fair Debt Collection Practices Act. So in this sort of fraud, this might be with an insurance company, it might be with some other company that they lied to you. But you have to meet specific elements, and these are pretty standard across the country. So number one is there has to be a misrepresentation or a suppression. So there has to be a lie or the hiding of something. So that's number one. Number two, it has to be of a material fact. Material fact just means it's important. It would make a difference. Okay, so I'm buying a car from you and you say, this car has never been wrecked, and it has been wrecked. Well, that's important to me. Maybe I wouldn't have bought the car had I known it was wrecked. But if I say, well, you told me it had 29,003 miles and it actually had 29,003.1 miles. Well, that's probably not material. So again, we need a lie about something that's important, and then we need reliance. So if I'm claiming somebody defrauded me, I have to show they lied. So if they told the truth, then that's no problem. It has to be important, a material fact, and I have to rely on it. I have to change something. And some courts call this reasonable reliance. Some call it justifiable reliance. Kind of different definitions. But what it means is it was appropriate for me to rely upon the lie. So if you're selling me oceanfront property in Arizona, for you George Strait fans out there, if you're selling me oceanfront property in Arizona, did you lie? Yeah, you told me that this property was oceanfront in Arizona. Is it important? Yeah, that's a really critical fact. I mean, do I have an ocean view with this property? So you lied to me. It's really important. But was it reasonable for me to believe that there is oceanfront property in Arizona? No, that's not reasonable. That's not justifiable. And so I would lose. But if we have a lie about something important, and there's proper reliance, then we look at damages. So did this actually harm me? Did I overpay for something? Did I buy something I wouldn't have bought? Did I take some action that I would not have done? So we might have, and I've had this many times, where a mortgage company will put in writing, hey, we will not foreclose on you until you have 14 days to get us these documents in what's called loss mitigation. So we're trying to stop a foreclosure, and they say, we'll give you 14 days and we will not foreclose during those 14 days. And so I, as the consumer, the homeowner, I say, is that something important? Absolutely. It's the foreclosure of my house. Did I rely on it? Yeah, I believe the mortgage company. Who else in the world would know what the mortgage company is going to do? Well, if I get them the documents on day 13, but they foreclosed on day 10, I've been damaged. Now I've lost my house. And so, again, we go through the elements, say, did they lie? Yeah, they told me I had 14 days. I really did. Is it important? Oh, yeah, it's incredibly important. Did I properly, justifiably, reasonably rely on it? Yeah, I did. Was I damaged? Oh, yes, I was damaged by it. So that's what fraud is. Now, we kind of have two types of fraud, or two categories. One is called a misrepresentation or a lie, and that's literally somebody just lying about something. This car has never been wrecked and it has been wrecked. That's pretty easy. The other type is called suppression. And that is where we suppress or we cover up the truth. Okay? So it's not that we outright lie, but we are holding back something that's critically important. So if somebody says, hey, look, I only want to buy this car if it's safe. I'm going to put my family in there. And can you tell me, has the car been wrecked? And I say, never been wrecked. And truthfully, it's never been wrecked. What I don't tell them, but what I know is, as soon as you go over 30 miles an hour, all four wheels fly off the car. the doors fall off, the seats fall out onto the, if you're on the interstate, they fall out onto the interstate, and everybody will die. And I just don't say anything. See, I didn't lie, but I suppressed the truth. That's really, really important. That has to do with health and safety. And I knew this person was needing this information, and I purposely hid it from them. That would be suppression. So I'll just tell you, as a lawyer, when we're suing for fraud, I just filed a case today against a big bank for fraud. We typically will put in the misrepresentation and the suppression, because in a way they're kind of like two sides of the same coin. I mean, did that guy lie to me, or did he withhold the truth from me? Sometimes it's hard to tell, so we plead both of them. There's one final thing that sometimes you'll run into. It's called promissory fraud. At least that's what it's typically called. And it's the idea, if you think about this. So you asked me, has a car ever been wrecked? Okay, so here we are right now. I'm looking back into the past and saying, nope, it's never been wrecked in the past. Okay, well, that's not promissory fraud, because that's a current fact right now. But if I say, hey, pay me $5,000 today, and 2 weeks from now, I'll deliver the car to you, and then I don't, is that fraud? Well, the law's a little skeptical about that, because we don't want every breach of contract to turn into a fraud. So what the law typically says is that when I made that statement to you that, hey, pay me the $5,000 now, and in 2 weeks I'll deliver the car to you, if I know in my mind I will never deliver that car, I mean, I'm just absolutely lying to you. I have what often is called the present intent not to perform. So I know right now I absolutely will never do what I'm telling you I will do. Well, then that may be promissory fraud. So it's fraud in the future. So again, kind of think in a timeline. If you ask if the car's ever been wrecked, that's looking back in time. But if it's something in the future, that's looking forward. And so right now, when I make that statement concerning a future event, I must have the present intent not to perform for that to be actionable, for us to be able to sue on that. And there's all sorts of exceptions, but I'm just giving you kind of the general lay of the land here. So hope that you found this helpful. If there are any of these sort of common law torts that maybe you're interested in, we talk about trespass or nuisance or recklessness or whatever it might be, feel free to either send me a direct message or just put it in the comment, and I'll add that to our list. And I appreciate you guys watching, and I'll catch you in the next video. Okay, bye-bye.